Hello and welcome to this episode of our series on data protection and pensions, brought to you by the pensions team at Gowling WLG. I'm Ian Chapman Curry and I've been dealing with all things data as the pensions industry gets ready to comply with the GDPR. As always, you can get more information on this and all our other pension insights at www.gowlingwlg.com/pensions-UK. In this episode, we'll be looking at how pension scheme trustees should work with third-party service providers and advisors to ensure compliance with the GDPR. Under the GDPR, data processors will, for the first time, have direct legal duties under data protection legislation. Many pension scheme trustees use third parties for professional advice and to help run their scheme. What will trustees have to do to ensure compliance by these third parties? The key points for this episode are that trustees usually rely on third parties. Third parties usually play an important role in the running of a pension scheme. Service providers and professional advisors need to use the scheme's personal data in order to help trustees run their scheme. Third-party data processors must provide sufficient guarantees. Under the GDPR, data controllers can only use third-party data processors that provide sufficient guarantees that they will comply with the GDPR. Trustees will need to carry out due diligence on their third-party service providers and professional advisors to determine whether they provide sufficient guarantees. Certain contractual terms need to be in place between trustees and third parties. The GDPR requires specific terms to be in place between data controllers and data processors. These include general statements and stipulations that data processors must be able to give. Trustees will need to gather and retain evidence of how third parties comply. Contractual terms are not enough. Third parties will need to provide evidence of how they comply. This might come in the form of a standard form statement explaining the data and security measures that the third party has put in place. Trustees should keep records of this evidence to demonstrate their own due diligence. Why are third parties particularly relevant for pension scheme trustees? Many trustees rely on third-party service providers to administer their pension schemes. For such schemes, the bulk of data processing is carried out by third parties. In addition, trustees have to appoint professional advisors such as actuaries and lawyers. These advisors usually have to use the scheme's personal data in order to provide advice. What third parties do trustees need to think about? Pension scheme trustees need to think about any third parties that process the scheme's personal data on behalf of the trustees. For most pension schemes, this will include scheme administrators, including employers that provide scheme administration services, professional advisors, including the scheme's actuary and legal advisor, and other third-party service providers, including beneficiary and missing member tracing services, independent medical advisors, online document and meeting platform providers, and any other third-party service provider that processes the scheme's personal data on behalf of the trustees. What legal duties will trustees have in respect of third parties? There are two main legal duties that apply in respect to third parties. The first are the required contractual terms in place. Pension scheme trustees are data controllers for the purposes of the scheme's personal data. Under the GDPR, data controllers have to ensure that there is a legally binding contract in place between them and any third parties that process the scheme's personal data on behalf of the trustees. The GDPR specifies a range of terms that need to be included in a contract between data controllers and third-party data processors. Secondly, does the third party provide sufficient guarantees? Under the GDPR, data controllers should only use third-party data processors that provide sufficient guarantees that they will implement appropriate technical and organisational measures in order to comply with the GDPR and protect personal data. Data controllers will therefore need to satisfy themselves that existing third parties provide sufficient guarantees. In addition, when appointing a new third party, data controllers will need to carry out due diligence to ensure that the third party will provide those sufficient guarantees. So what are the required contractual terms? The GDPR requires certain terms to be in legally binding contracts between data controllers and data processors, and between data controllers and other data controllers when they act together as joint controllers. There are 3 types of terms that may need to be included. If the third party is only a data processor, only the first 2 sets of terms need to be included. If the third party is a joint controller, then all 3 sets of terms need to be included. So, what are the first set of terms? These are statements about the processing. In order to be compliant with the GDPR, the contract between a data controller and the data processor should include statements that cover the subject matter of the processing, the duration of the processing, the nature and purpose of the processing, the type of personal data that is being processed, the data subjects or the categories of data subjects whose data is being processed, and the obligations and rights of the data controller. The second set of terms are stipulations that apply to the data processor. In order to be compliant with the GDPR, the contract between a data controller and the data processor should also contain stipulations that the data processor will only process on the documented instructions of the data controller, ensure that authorised persons who process the personal data are bound by confidentiality obligations, take steps to comply with the GDPR's requirements covering the security of processing, only engage sub-processors on the specific or general written instructions of the data controller, assist the data controller in complying with various obligations such as data subject rights requests and breach notification, delete or return the personal data at the end of the contract with the data controller, and to be able to demonstrate how the data processor has complied with its obligations under the GDPR in terms of providing information or being part of an audit process. The third set of terms are those covering the relationship between joint controllers. In order to be compliant with the GDPR, a contract between a data controller and another data controller in a joint controller relationship should set out their respective responsibilities, roles, and relationship, how the parties will comply with the GDPR, in particular dealing with data subject rights requests and communicating with data subjects, i.e. who's going to be responsible for providing privacy notices. In addition, the joint controllers need to make the essence of this agreement available to data subjects, and this will usually be done via the privacy notice. So how can a trustee assess whether a third party provides sufficient guarantees? As data controllers, pension scheme trustees should only appoint third-party data processors that can provide sufficient guarantees that they will or have implemented appropriate technical and organisational measures in order to comply with the GDPR and ensure the protection of the rights of data subjects. Does a contractual term stating that the data processor will implement appropriate technical and organisational measures provide these sufficient guarantees? It's our view that on its own, no. This is especially the case if the data processor's day-to-day practice does not actually meet the standards that they have set out in their contracts. For example, the contract might stipulate that emails will be password protected, but if you know in practice that the third party rarely, if ever, password protects emails, then the contractual provision doesn't provide much guarantee. The contract can, however, be part of the evidence that the trustees will need to satisfy themselves that the third party has provided sufficient guarantees. So let's go to the other extreme. If we can't necessarily take the word in a contract, is a third-party external consultancy required to give a professional opinion? How can trustees make a judgment of whether a third party provides sufficient guarantees? Will they need to appoint a consultancy to provide expert advice on data protection and data and cybersecurity? This will depend on the situation. It might be appropriate where the trustees have particular concerns about the data processor. It might also be a good idea if there is a particularly high volume of sensitive personal data. Trustees that use recognised names in the pensions industry may not, however, need to go this far. Are there industry standards or codes of practice? It would certainly make trustees' life a lot simpler if there was a single standard or code of practice that was independently verified and demonstrated compliance. And there are a raft of existing British and international standards covering a range of relevant areas, such as document management and data and cybersecurity. At the time this recording was made, however, a single standard or code of practice has not yet emerged. So how are trustees going to decide? Trustees are likely to have to weigh up a range of factors, and this will include the information that has been provided by the third party. Most pensions industry data processors are setting out revised terms and conditions and issuing statements on how they, as an organisation, deal with data protection. So what additional evidence should trustees compile? Evidence that a third party provides sufficient guarantees could come from a variety of sources, including those contractual terms, perhaps including a schedule of key performance indicators, also replies to questionnaires and data mapping exercises, and replies to specific inquiries. In addition, organisations might issue standard statements on how they plan to comply with the GDPR and issue data protection and data and cybersecurity statements. So what are the main things that pension scheme trustees will have to do next? Make a list of the third parties that process the scheme's personal data. Trustees should consider all of their third-party service providers and professional advisors and any other third parties, for example, the scheme's employers. It might be useful to create a diagram or map rather than a list. Ask relevant third parties to complete a data mapping questionnaire. Third parties are only relevant for data protection purposes if they process the scheme's personal data. Processing covers a wide range of activities, but there are exceptions. For example, the Royal Mail is not processing data if they only hold a document or a USB memory key in order to deliver it. If the third party only receives anonymous data or scheme-level data that does not identify a living natural person, they will not be dealing with personal data and can be discounted from this process. Ask relevant third parties whether their terms are GDPR compliant. Many third parties are putting in place variations to their standard terms and conditions, especially to deal with the requirements for specific terms under the GDPR. Have all of your third parties provided such variations? Have you had them reviewed by the scheme's lawyers? Ask third parties how they provide sufficient guarantees. Trustees should ask third parties to provide evidence of how they will comply with their duties under the GDPR. This may come in the form of responses to a questionnaire, a standard form response covering data protection and data and cybersecurity, a page or section of a website, or any combination of these. It's important for the trustees to keep a record of this evidence so that they will be able to demonstrate the due diligence that they carried out on their third-party service providers and professional advisors. And if that has whet your appetite for all things data protection, don't forget there is far more information available at www.gowlingwlg.com. We've made all of these episodes available to read, watch or listen to whenever you want. Please do share them with anyone who is dealing with data protection issues. Thanks for making the time to join us. I hope you can join us for another episode of Gowling WLG's Data Protection and Pension series soon.